What if I told you that while you've been working hard, paying your taxes, following the rules, and waiting for your green card, the rules have just changed? What if I told you that Congress has quietly passed new immigration laws, 10 of them, that could directly affect your ability to get a green card, stay in the United States legally, or even keep the status you already have? What if one small mistake, one missed deadline, or one overlooked update meant that everything you've worked for, your family's future, your job, your safety, your dream of becoming an American, could be taken away? This is not a warning for someone else. This is not about someone living in another state or applying for a visa you don't need. This is about you. If you are applying for a green card, if you are a visa holder, if you are a permanent resident, if you are trying to bring your family to the US, or if you are simply living here and hoping to stay, then you need to stop everything and listen to this. Because what I'm about to tell you could change your life. And the scariest part? Most people have no idea these changes are already in motion. This is Immigration News Today, and I'm James, your trusted source for breaking U.S. immigration updates, policy shifts, and the urgent information you need to protect your status and your future in America. What we are seeing right now is not just another news cycle. This is a real, tangible transformation in how the United States is handling immigration, and it all centers around new laws that Congress has passed, changes that USCIS is now enforcing, and updates that will hit your case, your interview, your application, or your travel plans harder than you think. Now, I know what you're thinking. Another immigration update? Another video warning me about deadlines and documents? But this time, it's different. This time, we're not talking about minor adjustments or procedural tweaks. We are talking about brand new legislation that fundamentally changes how green cards are issued, who qualifies, how long you can stay, what documents you must have, how you prove your eligibility, and even how you prove you won't become a public charge. That's not speculation. That's not fear-mongering. That is the reality of 10 new immigration laws, all passed or enacted in the last few months, that you need to know about right now. So let's break this down, not as lawyers, not as politicians, but as human beings who understand what's at stake. Because behind every statistic, every policy change, every new form or rule, there is a real person, a mother, a father, a student, a worker, a dreamer, someone who came to this country with hope and now faces uncertainty because the rules changed overnight. Let's start with the most urgent issue. Congress has just made major changes to how green cards are approved, and the requirements are stricter than ever. In 2024, several new laws went into effect that directly affect employment-based and family-based green card applications. One of the biggest changes? The income and financial sponsorship requirements have gone up significantly. That means if you are applying for a green card through a family member or employer, that person, your sponsor, must now prove they earn significantly more money than before to qualify as your financial supporter. USCIS is cracking down on what they call public charge risks, the fear that you might one day need government assistance. And they are using your sponsor's income as a key measure of whether you're likely to become dependent on the system. If your sponsor doesn't meet the new income thresholds, which are now tied to the federal poverty guidelines and adjusted for household size, your green card application could be denied. That's right. Even if you've done everything else right, even if you've waited years, even if you're married to a U.S. citizen or have a job offer in hand, if your sponsor doesn't make enough money, your application could be rejected. That's why it is more important than ever to double-check the latest financial requirements before you submit any green card paperwork. Go to the USCIS website, review the latest public charge rule updates, and if you're not sure whether your sponsor qualifies, talk to an immigration attorney or accredited representative before you file. Next, Congress has expanded the use of biometric data collection for nearly every immigration application. That means if you are applying for a green card, a visa, or even just extending your stay, you will likely be required to provide fingerprints, photos, and even iris scans more often and at more stages of the process. USCIS and CBP, Customs and Border Protection, are now using advanced technology to track applicants across multiple databases, and if you refuse or fail to complete your biometrics appointment, your entire case could be delayed or denied. Watch your mail carefully. USCIS will send you a biometrics appointment notice, Form I-797C, and you must attend that appointment on time. Missing it is not an option. If you reschedule too many times, USCIS may close your case or deny your application. Use the USCIS Online Case Status tool, available at uscis.gov Case Status, to track your appointment and your overall case progress. It's free, it's official, and it could save your immigration future. Now, here's something a lot of people don't realize. Traveling outside the U.S. while your green card application is pending has become extremely risky. A new law now flags certain international trips during adjustment of status as potential abandonment of your application. If you leave the United States without the proper travel document, like advance parole, while your green card or adjustment of status application is in process, USCIS can consider your application abandoned. That means you could come back to the U.S. only to find out that your case has been denied, your status has lapsed, or worse, you're denied re-entry entirely. If you must travel internationally while your green card is pending, you must apply for and receive advance parole before you leave the country. Do not rely on your visa. Do not assume you can just come back in. Get the proper paperwork. Check the latest travel rules. And if you're not sure, ask a lawyer, because once you're outside the U.S., it may be too late. Speaking of advance parole, let's talk about another major change. The processing times for advance parole applications have increased dramatically in 2024, and denials are on the rise. USCIS is now reviewing these applications with much greater scrutiny, especially for applicants who have prior immigration violations, criminal records, or incomplete paperwork. If you apply for advance parole and your application is denied, you could be stuck outside the U.S. for months, or worse, permanently barred from returning. That's why it's critical to submit a complete application, include all required supporting documents, and double-check your eligibility before filing. If you're unsure whether you qualify, don't guess. Get professional advice, because one mistake on your advance parole form could cost you everything. Now let's shift gears to another major area of concern: work authorization and EAD cards. A new law has made it harder for certain green card applicants to get or renew their employment authorization documents, or EADs. If you are applying for a green card through adjustment of status, you may no longer automatically qualify for a work permit, especially if your priority date is not current or your category has changed. USCIS is now reviewing EAD applications with stricter eligibility standards, and delays in processing are causing real financial hardship for families who depend on those work permits to survive. If you have an EAD that's expiring soon, don't wait until the last minute to renew it. File your I-765 application at least 180 days before it expires. Check the latest visa bulletin to see where your category stands, and monitor your case status closely using the official USCIS tools. Because if your EAD lapses and you're not eligible for an automatic extension, you could lose your job, your income, and your ability to support your family. Here's another big one. The public charge rule is now being enforced more aggressively than ever. You've heard the term before, but here's what it really means. If USCIS believes you are likely to depend on government benefits like Medicaid, food stamps, or housing assistance in the future, they can deny your green card application, even if you've never used those benefits yourself. The new laws expand the types of programs that count toward public charge determinations, and USCIS officers are now trained to look at your age, health, income, education, and family size to predict whether you might need help someday. That's why it's more important than ever to provide strong evidence of financial stability, employment, and health insurance when you apply for any immigration benefit. Include pay stubs, tax returns, letters from employers, and proof of private health coverage. The more you can show that you will not become a public charge, the stronger your case will be. Now let's talk about another issue that's affecting thousands of families right now: the new restrictions on family-based green card sponsorships. Congress has passed laws that make it harder for U.S. citizens and permanent residents to sponsor certain relatives, especially siblings and adult children. Wait times are increasing, quotas are tighter, and in some cases, entire categories of family-based green cards have been delayed or deprioritized. If you're trying to bring a parent, sibling, or adult child to the U.S., you need to check the latest visa bulletin and understand your category's priority date. Some family-based green cards are now taking 10, 15, even 20 years to process. If you're not in a high-priority category, like spouse or unmarried child under 21, your wait could be even longer. Plan accordingly. Explore other immigration options. And don't assume that just because you're a citizen, your relative will get a green card quickly. Another critical change that's flying under the radar: the new laws have strengthened penalties for immigration fraud. That includes false statements on applications, fake marriages, forged documents, and misrepresentations during interviews. USCIS and ICE are now using advanced data sharing, AI tools, and cross-agency cooperation to detect fraud, and the consequences are severe. If you're caught lying on a green card application, even by accident, you could be permanently barred from the United States, deported, or even criminally prosecuted. That's why it is absolutely essential to answer every question truthfully, provide accurate documents, and never rely on advice from unauthorized sources. If you're not sure how to fill out a form or what information to include, get help from a licensed immigration attorney or an accredited representative. Don't risk your future on a DIY application or bad advice. And finally, one more urgent update. Congress has mandated new reporting requirements for employers sponsoring foreign workers. If you're applying for a work-based green card through your employer, your company must now provide more detailed documentation proving that the job offer is legitimate, that you qualify for the position, and that no qualified U.S. workers were passed over. USCIS is auditing these cases more frequently, and if your employer fails to meet the new reporting standards, your green card application could be denied. If you're working with an employer-sponsored pathway, make sure your company is aware of the new rules and is submitting all required evidence on time. If you're unsure whether your employer is compliant, ask questions, get clarification, because your immigration future may depend on their paperwork. So, what do you do now? How do you protect yourself in this rapidly changing environment? First, stay informed. Bookmark the official USCIS website. Subscribe to updates from the Department of State. Watch this channel, Immigration News Today, where we break down every major policy change, every court decision, and every deadline you need to know. Second, track your case. Use the USCIS Case Status online tool, uscis.gov Case Status, to monitor your application, check your interview date, and see if USCIS has sent you any requests or updates. Third, respond quickly. If you get an RFE, a NOID, or any notice from USCIS, treat it like an emergency. Missing a deadline can mean losing your case. Fourth, get help if you need it. Don't navigate the immigration system alone. Talk to a lawyer. Ask questions. Get professional guidance before you file anything. And most importantly, don't give up. Yes, the rules are changing. Yes, the process is harder than ever. But millions of people before you have fought to build a life in this country, and you can too. The key is knowledge, preparation, and action. Thank you for watching Immigration News Today. If this video helped you, please like it, share it with someone who needs to hear this, subscribe to the channel, and turn on notifications so you never miss an update. And please, Leave a comment below. Tell me what immigration questions you have. What topics you want us to cover next. Because your voice matters. Your future matters. And together, we will keep fighting for the truth, the facts, and the American dream. Stay strong, stay informed, and we'll see you in the next video.